Good morning, everyone. In the history of the U.S. Constitution, it's time to tackle or discuss Article 3 of the U.S. Constitution, the Judiciary. It's, although all parts of the Constitution are my favorite, I tend to gravitate towards Article 3, the Judiciary, because I practice law and I feel it's a very important and interesting aspect of constitutional history because there, more than any other branch, has its interpretation and strength changed since the very early inception of our Constitution in 1789. 1787 was the proposal. 1789 we adopted. We know Article 3 is a judiciary. It creates only one court at that inception. That's the United States Supreme Court, which will have jurisdiction over all questions dealing with the Constitution, federal statutes or federal law, and federal controversies, as well as treaties. And why I was going to say federal treaties, but we know there only can be federal treaties because the Constitution vests all foreign policy in the power of the executive with the consent of the Senate. And therefore, no state can enter into any kind of foreign treaty on their own. So it also deals with controversies related to treaties. The thing I want to stress, and the book does jump around a little bit, is some matters under federal law. And remember, Supreme Court can only hear what kind of cases? Those dealing with federal law. The Constitution, statutes, administrative rules and regulations, those dealing with foreign counsel and diplomats, treaties, but it has to be a federal question involved, or they simply lack jurisdiction. Jurisdiction is the power of a court to hear a matter. I'm not going to get too deep in it. There's two kinds of jurisdiction. Jurisdiction over the party, called personal jurisdiction, which we're not going to deal with at all in this class. The others, subject matter jurisdiction. Can they hear the type of case? The Supreme Court is a court of limited jurisdiction. It only hears federal controversies. And then it doesn't always hear them as a trial court. It doesn't hear it as a court of original jurisdiction. You don't start there. Most controversies that the Supreme Court will hear are those that are on what we call appeal. They've already had a trial. They may have already had one determination at an appellate court level, but they are not usually the trier of fact and the applier of law. They are interpreter of errors of alleged law that occurred at a trial court or at an appellate court level that was lower than themselves. So just to read from specifically, it says, in all cases infecting ambassadors, obviously federal, right? There's no such thing as a state ambassador, other public ministers and consuls, all on the federal level, in those in which the state shall be a party, the Supreme Court shall have original jurisdiction, meaning you can start right there. The lawsuit can start right in the Supreme Court if it's over these kind of federal officials and or one state suing another state. In all other cases, which is going to be the vast majority of cases, on a federal question, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. This is one of the important things that people don't realize. The Congress actually has the power, the legislative branch actually has the power to curtail and limit the appellate jurisdiction of the Supreme Court. They haven't messed with it in many, many years. There's argument right now that if the legislative branch were to curtail the authority of the Supreme Court to hear appellate matters on the federal level, it would disrupt what we consider to be the checks and balances. And I think the Congress would likely behoove that sort of warning that even though the Constitution clearly grants it the power. So the argument is, could the United States Supreme Court be stripped of its power to hear appellate cases dealing with some federal statute that somehow limits or challenges access to abortion rights for women? And people say, well, it would go to the trial court, then it would go to maybe the Circuit Court of Appeals for that region, and then it would go to the Supreme Court. But could the Congress say, Supreme Court, we're taking away that appellate jurisdiction by law? They would pass it, and the president would have to endorse it. It becomes a new law as to the jurisdiction of the court's appellate realm. Yes, it could. It's unheard of. It's very unlikely to happen. But you should know that the framers did give the legislative branch a check on the court by giving it the ability to curtail, limit, or increase or decrease the appellate jurisdiction of the United States Supreme Court on federal question. It has to be a federal question. What do I mean federal question? This perfect example is Massachusetts' initial gay marriage case that came out of the Massachusetts court system, not the federal court system. The case is called Goodrich versus the Board of Health. It went through the state court system arguing state constitutional principles. And it went to the Supreme Court of Massachusetts. We call it the Supreme Judicial Court. There, the court, not dealing with any federal law, not dealing with an argument under the federal Constitution, but only under the state of Massachusetts Constitution, Supreme Judicial Court of Massachusetts determined that gays and lesbians have an inherent right to marry as adult consenting couples to the institution of marriage under our state constitution. And a lot of people celebrated that, thought it was great. Some people wanted to fight that. And their argument was we should take this court case to the Supreme Court of the United States so it could overturn the Massachusetts Supreme Court because it is a higher court, but only a higher court when it comes to the jurisdiction of federal questions. The Goodrich case in Massachusetts had no federal question. It's a court of limited jurisdiction. The framers didn't say, Supreme Court of the United States, you can hear any kind of case you want. They listed the kinds of cases they could hear originally, right from the start, which is very few, but those that are appellate jurisdiction are over federal law. So they'll only deal with questions under the federal Constitution or the Bill of Rights, which is part of the Constitution, obviously, a federal administrative rule or regulation, a federal statute, or federal treaties. And there's only one kind of treaty anyways, federal. Other than that, the Supreme Court doesn't even have the power to hear it, even if they wanted to. That's the first important aspect that we have to get to. What is the court's jurisdiction? But the second thing, what is the role of the judiciary? What is Article 3? It's the most brief of the three articles that set up the framework of government. There's 7 articles in this the constitutional framework of government, but the first 3 set up the 3 branches. Article 1 is much more lengthy than Article 2, and the least, and it's very scant, is Article 3, setting up basically the federal judiciary, stating that there be one Supreme Court, telling us what its jurisdiction would be, and then stating that the legislature had the power to create many other federal lower courts as it wished. So initially we started off with just one court, then eventually the legislature got around to creating district courts where most of the original jurisdiction where trials will actually be held and initial charges or civil controversies will be had if there's a federal question. And then it created the circuit courts of appeal. I believe there are 13 circuit courts of appeal based upon geographical regions, and it takes up so many states. We live here in Massachusetts in the first circuit court for appeals. Every state has at least one federal district court, or what I call trial court, or court of record or original jurisdiction. Massachusetts has 3. We have one that sits in Springfield, Massachusetts. We have one that sits in Worcester, right across from the Hanover Theater, if you guys know Worcester at all, right on Main Street. And then there's one that sits in Boston. We have 3 in Massachusetts. Other larger states have several or less, depending on how small the state's population is, for a federal district court. But everyone has at least one. And then they're members of the different circuit courts of appeals. And we have one United States Supreme Court. Now, what gives the Supreme Court all of its authority? I would argue that the framers weren't all that clear about how much authority and power they would have other than being interpreters of law. A famous case comes along, and this is what I really want you to know for the exam, more than maybe other cases, but it's called Marbury versus Madison. And what happens is initially the Supreme Court's a bit, well, it's anemic. It doesn't seem to have a very clear vision about what its purpose is or how it may be a check in the 3-tier section of government between the legislature, the president, and the judiciary. The judiciary is sort of, I don't call it odd man out initially, but there really was very little significance from the Supreme Court in its early iteration. John Jay was the first Supreme Court justice. For a while there was 6 justices, and at one point we had 10. We finally settled by legislation because there's nothing in the United States Constitution that says it'd be 9. We finally settled at 9. But people like Alexander Hamilton, and who are the other great American citizens that basically didn't want to sit on a court because it was lacking in significance. It just didn't have a lot of, in fact, John Jay resigned being Chief Justice of the Supreme Court to become governor of New York. It was considered much more strategically important as a politician in the time. Just seeing who the other ones that passed it up. There were some mentions in it here. I know one was Alexander Hamilton passed it up. It's really fascinating. I can't find them all at the tip of my tongue. I should have underlined that section. But it really was not considered to be that prestigious a branch of government. It wasn't always clear that it had the ability to act as a check on the legislature and the presidency. It all changes in 1803. In 1803, a famous case comes along. It's Marbury versus Madison. And you guys don't need to know so much the facts about it. You need to know what the ruling or the holding was, which is most significant. But it's always nice to have some context. What the hell happened, right? There's this guy named Marbury. He gets a judgeship. I don't know where it was to. Maybe it was even to the D.C. Circuit. I don't know. He gets a modest judiciary federal position from John Adams. And it's called a midnight appointment. There's a lame duck period when presidents will, after they lose or are out of office because they decide not to run again, they often do things like pardons, but they also try to appoint a lot of people. And we know it's right in the Constitution. When a member of the federal judiciary is appointed, it's a lifetime appointed. It's considered a very good position financially and in terms of being at the pinnacle of being in a law profession. So John Adams appoints one of his cronies, this guy, Marbury, and it gets approved by the Senate because every time that's one of the checks and balances, the judiciary is picked by the president with the consent and advice of the Senate. So if John Adams picked one of his cronies in the legislature, the Senate bicameral branch of the legislature approves of that, they pretty much have it. But there's a third step. The Secretary of State has to give you basically a parchment or issue a citation saying you're now the judge. Well, guess who was the Secretary of State back then in 1800? Well, it was Justice John Marshall, the greatest justice of all times. Well, at the end of his term, he gets appointed to the Supreme Court. He's very busy. He goes on to the Supreme Court. He never gets around to issuing this citation to this guy Marbury. Marbury wants his judgeship. So he goes to the new Secretary of State, who was very much at odds with John Adams' administration, a guy by the name of James Madison, who becomes later the president. And it's Thomas Jefferson. Jefferson says, hey, Madison, don't give any of these citations out that weren't formally finished by John Marshall, the former Secretary of State. And so, like any civil society, what do you do when you have a grievance? You sue. And so Marbury versus Madison is just that. Marbury sues James Madison for his position as a judge. And where do they sue? They sue directly in the United States Supreme Court under the Judiciary Act of 1791, which expanded, the legislature tried to expand the original jurisdiction of the Supreme Court. It gets up there, and John Marshall is so freaking brilliant. He's unbelievable. Thomas Jefferson doesn't like John Marshall. I believe they're actually first cousins. They're both out of Virginia. One's a Federalist. The other's a Republican Democrat. They're very much at odds about the nature of how our government should be run and the scope of government and all of those kinds of questions. So John Marshall, if he ruled that Marbury, I'm going to grant, the Supreme Court's going to order that Madison give you that judgeship, what could Madison maybe do in this early stages of our country? They might just have ignored it. And what would that do to the Supreme Court's efficacy and power? It would make it just basically like almost an advisory body, right? It would limit its ability to be a real check on government. So John Marshall, being as brilliant as he is, says, you know what I'm going to do? I'm going to rule that although I think Marbury certainly deserves and has met all the requirements to be a judge under the appointment process, this case cannot be heard in the United States Supreme Court under original jurisdiction because the Judiciary Act of 1791 expanding our original jurisdiction is unconstitutional, because the only way to change the Constitution, which gave us our list of original jurisdiction, is by amending the Constitution. So no president, no legislature can tweak, change, or modify the language that's in the Constitution in terms of its power, unless it was granted in the Constitution. And it wasn't. And so, in a sense, Thomas Jefferson wins the case. He doesn't have to give the job to Marbury because basically the court says we don't have the authority to do that. But what does John Marshall do in the ruling? He says, as the Supreme Court, we determine those laws that are constitutional and unconstitutional emanating from the federal legislature. We are the final arbiter of what the Constitution means. This kind of shocked Thomas Jefferson. Jefferson was seething over this opinion. The book seems to suggest that it didn't make a lot of waves in its time, but it certainly did. There was a real recognition that this arguably is a power grab by the United States Supreme Court. stating that they're the final arbiter of what the United States Constitution means. People say this was a novel concept, that out of nowhere the Supreme Court just basically snatched authority. That's not necessarily true. There were arguments made at the Philadelphia Convention about the ability of the Supreme Court to maybe nullify laws that were deemed to be in contravention of the United States Constitution. And even Alexander Hamilton, who peddled, that's a terrible word, but basically promoted the adoption of the United States Supreme Court, wrote many of the Federalist Papers, and the most influential on the judiciary was Federalist Paper number 78. He said that the Supreme Court or the judiciary will have very little power vis-a-vis the president and the legislature because it doesn't have the power of the sword as the executive has, commander-in-chief, and it doesn't have the power of the purse, the legislature, and it doesn't have the power of making the rules and the laws, the legislature. All it has the power to do is interpret law. But in that, Hamilton said, it would have the power to determine whether a law is void as against the mandates of the Constitution. So there was already much talk about the judiciary potentially having the power to declare a law or a principle unconstitutional that was being exercised by one of the other branches of government. But this was the first act that did it. It changed exponentially the whole role of the Supreme Court, because other the legislature comes with, well, why can't we declare what's constitutional and unconstitutional? Why don't we have the same say or the same power? Why can't the president determine what's constitutional and unconstitutional? Don't we all stand up in a promise to abide by the terms of the Constitution? Why is our say lesser than the Supreme Court? And the basic argument is because the courts are designed and trained and positioned for the very purposes of interpreting law, and the Constitution is the highest law of the land. So it really becomes a game changer. In later cases come down that will rule that the court can also strike down an act of the president, the executive. So Marbury versus Madison strikes down an act of Congress. Very first time it ever did it. Later, it will strike down acts of the presidents, saying it goes beyond the scope of the presidential power. And then perhaps just as significantly, later cases will strike down state law as being in contravention of the federal Constitution under the Supremacy Clause. That's a big deal because it creates more and more power for the federal government, but it also arguably creates, some people say, omnipotence, if you will, in the federal judiciary. Because remember, once the Supreme Court gets appointed, they serve for life. The only way to get rid of a Supreme Court member is death, resignation, or impeachment. And we've only had, I believe, only a handful of members of the Supreme Court have ever been impeached. I don't know if anybody's actually been impeached, just means to be charged. I don't know if any of them have actually been removed. And we've had arguably a few Supreme Court justices early on in American history. One with Solomon Chase was kind of a nut job, went kind of crazy on the bench. But we've had others that we don't always talk about that may have maybe been less than playing with a full deck near the end of their careers, because many of them don't want to give up the power. And I remember talking to my brother one time. We were watching Justice Thurgood Marshall when he was retiring. I don't know how old he was, but he was in extremely poor health, and he actually wheeled him out to a press conference, to announce his retirement. And I don't know, he was in his 80s, and he looked like he was, and he did die very shortly after. And my brother says, geez, he must have tried to wait to get the maximum retirement. I said, he was already set for life. And my brother's name is Joe. I said, Joe, he's already set for life. And he goes, well, why wouldn't he retire a long time ago? Why would you take on all that important work and things? It's the prestige and the power of the office that most members of the Supreme Court rarely, there's a few more. Justice Kennedy retired in fairly good health. The first woman justice, Sandra Day O'Connor, retired when she was still in good health because her husband was ailing and she wanted to spend more time with him. But many members of the Supreme Court, Ruth Bader Ginsburg is a perfect example. She died while she was in office with multiple illnesses, knowing full well she wouldn't last that long, because these 9 members of the Supreme Court wield an incredible degree of power in determining what our Constitution means. And other than 1 or 2 isolated cases, when the Supreme Court rules that a president can't do something, or must do something, or that the legislature can't create a law in a certain area, what do we do as a society? Other than one very significant case that I can think of, we follow it, often begrudgingly. If we don't like a decision of the Supreme Court, what do? We kick our tire in a car, and we slam the door, and we sulk in our bedrooms. But we accept it as that's what the law is. Charles Evans Hughes had a great quote, and it is your book. I'm glad he is in there. He's one of my favorite characters in history. After he left the Supreme Court as the Chief Justice, he became Secretary of State, and I believe Governor of New York. He very huge political power. Can remember the World Court later before his death. But he was the 1960 candidate after he left the Supreme Court. He left the Supreme Court to run for president in a Republican ticket. He lost to Woodrow Wilson. But his quote is one of my favorites. And his quote is, "We are under a constitution, but the Constitution is what the judges say it is." And that's basically what we live by. And I hate to do such a shorthand term, but the Supreme Court has that power. And there's where we get this sort of argument that there's three co-equal branches of government. I hate to call them co-equal, but three spheres of influence that have significant influence in a different branch that have impact on the ability of the other branches to become tyrannical or too powerful. So what can the Supreme Court do? If the president acts or does something that's contrary to the mandates and dictates of the Constitution, can strike down their action and tell them they can't do that anymore. And other than one example, which I'm going to talk about in a second, they followed that. And the same with the legislature. The legislatures often pass laws and somebody challenges it. The most recent one I'm thinking of is the Affordable Care Act. People challenge that, went to the United States Supreme Court in a very close decision. The Supreme Court said it was constitutional. It wasn't necessarily wise or provident. It was constitutional under the taxation power. But the one famous case I'm looking for deals with the Cherokee Indian Nation down in Georgia, and I believe it's the Worcester case. I do have to find it because it's one of my favorites. Of course, one thing I don't underline in my book is the actual title of the case. But they're often called the Cherokee Nation cases, but I'll just tell you what it is real quick here. I don't know why I can't find it. Yeah, here it is. It says right here, it says, well, just it doesn't even give you the title and name. It's just the Cherokee Nation. I'll certainly put it up in my notes or give you some other material. But basically, there was a treaty giving the Cherokees certain sovereign lands in the state of Georgia. The state of Georgia wanted to move these Cherokee natives off the land and move them west of the Mississippi River because the lands were valuable to future expansion of basically the white people in Georgia. And the Native Americans fought it, and they had some people that were sympathetic to them. So they brought it all the way to the Supreme Court, enforcement of a treaty, right? And the United States Supreme Court under John Marshall says that the state of Georgia could not remove those Native Americans. They had the right to stay there. They were a sovereign nation, and they had a valid treaty with the United States, and the United States had to honor that, and they could not be removed. And so basically it's a federal mandate they can't be removed. And so what did the president at the time, Andrew Jackson, still despised by many Native Americans to this day, Andrew Jackson said, "John Marshall now has made his ruling. Let him enforce it." And so basically Andrew Jackson basically flouted that opinion of the United States Supreme Court, and the Native Americans, called the Trail of Tears, basically marched all the Cherokee Nation all the way off their reservations in Georgia, all the way west beyond the Mississippi River. Many thousands died along the way, and it was a real tragedy. But it was at one time, the one time I can think of, where the federal government completely ignored a ruling of the Supreme Court. And the Supreme Court, to save face, shortly thereafter made another ruling in a case called Worcester. In that case, basically trying to suggest that they didn't have jurisdiction to hear part of that question. So they said, well, we don't really have the power to say it anyways. But the reality is oftentimes decisions are made that our presidents, our legislatures have been extremely upset about. And they often say that the power of these 9 people appointed for life with no responsiveness to our democratic process is abhorrent to a republic society, a democracy. But the reality is that's what the framers wanted. They didn't want a pure democracy. They wanted to check on popular decisions. They want the court to have the power to make decisions that are sometimes unpopular, but are constitutional in nature. And Nixon, even President Nixon, who was ordered to release the Nixon tapes because somebody argued they needed them. They were being indicted. They were part of the Watergate break-in, and they said the tapes would help protect them, that they were doing things under the order of the president, and the president knew well about it. Nixon said there's something called executive privilege, and I don't have to disclose conversations in the tapes that I have because we have a certain degree of privilege. And the Supreme Court actually agreed with him in part, saying there is executive privilege, but there's also a person's rights under the Fourth, Fifth, and Sixth Amendments to defend themselves in a criminal court of law. And that law is, or that constitutional provision is much more clearly defined and therefore will subvert any argument of executive privilege. And what did Nixon do? Did he say, I'm not giving over the tapes? Well, initially he did, but what did he do overnight? He honored the Supreme Court's decision and turned over the tapes. It might have destroyed some, I don't know, but he did turn over the tapes. The point is, we've come to a society today that we've come to acknowledge that the Supreme Court is the final arbiter on what the Constitution means. And we, as a legislature, as a president, as a lower state entity within our system of federalism, must honor what the Supreme Court says. Is there anything we can do about it? Well, one of the arguments is we can go and get different members on the Supreme Court. Some people argue about it as court packing, meaning we'll just put more members on, because remember, there's nothing in the Constitution that said there'd be 9 members. This was almost done under Franklin Delano Roosevelt. He and the legislature were passing many laws to help spur the economy during the Depression, and the Supreme Court was fairly consistent in its early rulings on these provisions that they were unconstitutional. The court said, hey, you don't have the power under taxation or to regulate commerce to create all these work project administration type of pieces of legislation to spur the economy. No matter how good or wise the law is, you don't have the power to do it. It kept shooting them down. Franklin Delano Roosevelt in the legislature and the American people became very, very frustrated with the Supreme Court. So what did he say? He says, we have several members of the Supreme Court that are over the age of 70, and the workload is very demanding. So we should expand the membership to 15. And if we expand the membership to 15, we can protect against people dying and becoming ill, or just lowering the workload. And there's no prohibition in the Constitution to make it 15. This was called the court packing scheme, and you have to know about this for the test. In the court packing scheme, it was extremely controversial, meaning liberals, progressives, conservatives, almost everybody thought the president was basically changing the 3 tiers of government and the checks and balances between them, because he was going to pack the court with whom? People that were independent and free-spirited, or was he going to appoint cronies that were going to do what his will was? And every president that appoints anybody always hopes they're appointing someone with the same philosophical and political views they have, and chances are the bulk of them might well follow what he wanted to have happen. He appoints loyalists. The old saying is, what happens when you appoint a friend to the United States Supreme Court? You no longer have a friend, because they can do whatever they want. They have a lifetime appointment. You can't take it back after. But it's considered to be a black mark on FDR. FDR did not follow through with it. The legislature did not tweak the numbers of the members we had on the Supreme Court. But the talk of it really made him look bad, because he's not getting what he wants. So therefore, he wants to basically do away with 1/3 of the government's checks and balances. It's very unpopular, and it stained, I think, his reputation to some degree. Now, we've had an election not that long ago. Joe Biden won. And in the election, there was an argument that because the Supreme Court had a lot of appointments from Donald Trump, that there's a new conservative membership on the court. In order to balance that, they should try to pack the court. There's a new argument for trying to pack the court, to put new additional members on beyond the 9 that are there. I think that would be a huge mistake. I think that's, again, a system by which we're trying to take away one of the branches of government when we're simply unhappy with that branch of government. Is there anything we can do then besides adding more members to the Supreme Court if we don't like what they're saying? Well, we can bring the issues back before them a second time. Meaning that, okay, say, I don't want to use the term, I don't know what the question might be. The Electoral College, some issue. We bring it to the Supreme Court, they rule a certain way. We're all very dissatisfied. Maybe it's the Affordable Care Act. Could we bring another case a year, 3 years later, with a very similar question under the Affordable Care Act and try to have it thrown out as unconstitutional? Absolutely. But there's a principle called stare decisis. That's a Latin term meaning let the matter stand. And so the court, even if it really is inclined to change its position because of new membership or new knowledge or a philosophical change in its makeup, it's really reluctant to change its rulings in a very short era. They usually need a lot of time to pass. Look at Plessy versus Ferguson, 1896, said separate but equal is okay. As long as African Americans had the same kind of travel cars as white people did, the Constitution was satisfied. There didn't have to be desegregation on public transport. It took until 1954, the Brown versus the Board of Education, and completely different membership on the Supreme Court, to reverse a decision all the way back in 1896. Courts are slow to overturn prior decisions they've made, even if it's made up of different justices within a few short years. So is there another check on them? The popular will is a check on the court. I think the court does look at the nature of the decisions and the ripple effect it will have in terms of society accepting its decisions as being valid and just. That's just my own editorializing. But what's the other one? What's the real one? Constitutional amendment. And we can do that. We can amend the United States Constitution. We did that. The 11th Amendment's mentioned in your book, for example. The original trial authority of the United States Supreme Court was one citizen sued another state, and it was opening up federal jurisdiction, and it was taking away state sovereignty. So that's one of the first amendments to the United States Constitution of the Bill of Rights, was the 11th Amendment, banning the Supreme Court or any federal court of hearing a lawsuit from one citizen of one state against the state of another. You may be able to do that in a state tribunal, but you can't do it in the federal one, because the 11th Amendment ended that process. So what are some of the debates that go on? If the Supreme Court does get appointments for life with the consent of the Senate, they are the final arbiter of what the Constitution means. So how should they interpret it? There's no guidebook, and there's different philosophies that develop, and your book does a fantastic job talking about originalism. Is a Supreme Court member supposed to use the political or legal philosophy of originalism? Whatever the original intent of the Constitution is, that's what I have to give meaning to it and apply it to the controversy before me. Then there's others that believe that the document is a living, breathing document, and it needs to adjust and adapt to the societal needs and circumstances of the day. Problem with that is it doesn't have a lot of parameters, and that sometimes can be cause of something we call judicial activism versus judicial restraint. I'm a big fan of judicial restraint. I am a liberal person on politics, but I am very conservative on legal theory. What do I mean by that? If I was on the Supreme Court and the law comes before me and it's challenged as being constitutional or unconstitutional, I would defer to the legislature unless I could see by the clear intent of the Constitution that the law should be stricken down. That's conservatism. That's what we call conservative, I already forgot it, originalism or restraint. What am I trying to do? I don't want to substitute my own political philosophies for the legislatures. That's their job. I can strike down and come out and say, this is the stupidest law I've ever heard of. It's made by a bunch of jokers and morons. But what should I do if I believe in judicial restraint and original content? I should uphold the law as constitutional. Others believe we should substitute our judgment to protect the American people for the best interests of the American people. That's the judicial activist voice. I don't really like that. And I don't understand necessarily the entire conception of the living, breathing document. The only thing that's living and breathing about it is the amendment process that we can do. I'm obviously editorializing and going way off, but you do need to know that there's different philosophies about how we determine the Constitution. So activism, or those that believe it's a living, breathing document, call it loose construction. John Marshall gave it loose construction. He interpreted it to have a lot of federal power for the nation because he was a nationalist or a federalist, and he also believed in expanding the Supreme Court's power through judicial activism. Justice Breyer, one of our current justices, believes in loose construction to help fit the needs of society into the constitutional interpretation. Others that I'm more akin to, not political philosophy, but legal philosophy, who is now dead, Justice Scalia. If these are what the words means, that's what I apply. I'm an interpreter. I'm like a referee. And John Roberts said this. John Roberts is a bit of a mix. Some people say he's conservative. Some people say he's liberal. He basically is like an umpire. No one goes to the game to watch the umpires, but the umpires apply the rules as they are written to the facts as they are delivered. And they make an outcome, whether it's popular or unpopular, based upon what the law requires. I'd like to think that's what I think of. So strict constructionist, matter of interpretation. There's a lot of controversy. People don't like the fact that we appoint these judges for a lifetime. If right now we have a lot of conservative justice, there's an argument that the majority at this date and time I'm making this video, that the majority of them are conservative. And those that have a more liberal or progressive bent say that's awful. We need to have terms, maybe 4 or 6 or 12 years before we get new justices in. But the same argument would hold true if we had the alternative. If we had mostly liberal or progressive judges right now, conservatives would be upset and say we need to do something about it. There are many, many people that really feel that this is the one branch that's not democratic, that's not responsive to the American people, and makes it very dangerous. I would argue almost exactly the same thing, except I'd give a different conclusion. It is distant from the will of the people. It is undemocratic, and it is a safeguard to protect minority views. And I don't mean minority in terms of ethnic or religion, but sometimes that's the case. But it's a bit immune from the political process, and that's what we want. I know when I go in front of a judge, sometimes I'll have a case where I'm like, geez, my client really did some stupid, really, maybe some bad things, but they didn't meet all of the elements of the alleged offense. And I want the judges to have the courage to apply the law, even if it has an unpopular consequence. And vice versa. What if I just had a really popular client and the law has clearly been satisfied and they're going to have to be punished? I wouldn't want the judge to say, but this guy's a good guy. Yeah, we like this guy. We want to do it based upon the person and not the rule of law. The court gives us, I think, that special prophylactic against the popular will that can be very, very dangerous, where the popular, the rich, the influential will have advantage over the unpopular, the destitute, the poor, and the disenfranchised. I kind of like the situation we have now where they're not elected. They are appointed with the approval of the Senate, and they sit for life. There might be an argument down the road that we might want to put some kind of, I don't know, I'm worried about people getting dementia and not necessarily leaving the bench. But just going back to Justice Thurgood Marshall, when he retired, my brother and I watched in the interview, we never laughed so hard in our life. They wheel him out in the wheelchair. He almost looks like he has no bones left in his body. He's kind of all slumped over, and they wheel him up. And he says, I served for X number of years, first African-American justice we ever had. One of my favorites. And he gets up there, but when I love this, closing remarks, and says, why are you retiring? And he basically went out into a profane response saying, what the hell's the matter with you? I'm dying. I'm falling apart. That was great. His mind was still well, but physically he couldn't do the job anymore. But there are some stories about Justice Douglas, who maybe was a little bit lost some of his mental acuity before he left the bench. And it's hard to leave when you have that much power. And that's the question. Should we in some state, now this is not the federal are all appointed and they all serve for life unless basically death, impeached, or resign or retire. Some states actually elect judges. I have mixed feelings about it. There was a time where here in Massachusetts I toyed with the concept of maybe trying to become a district court judge, and I thought, well, geez, how am I ever going to get the governor's attention or the judicial nominating committee's attention to get on board and get appointed? Then go in Massachusetts on a state level, we go through something called the governor's council for approval. We don't go to the legislature for approval, but there are checks in our system too on the state level. And sometimes I get a little angry thinking, well, you have to be part of the privileged society in order to get a judgeship. You have to be in with the who's who of influential politicians. And so I thought, man, it'd be great if you could run for office, and then it would be sort of an equal playing field. But then when you run for office, we'll get, not in this class, but if you're in my political science class, we talk about how the difficulty is running for office, having party affiliation and party strength, but also having a great deal of financial resources to get in. The same thing is true. I actually like our United States constitutional framework the way it does it. I'm glad we have Marbury versus Madison and established the concept of judicial review, the power of the court to strike down an act of Congress, in later cases, the act of the presidency or the act of a state legislature, as an unconstitutional act and therefore null and void. I think it creates a great deal of checks and balances, and I like it a great deal. Oh, video's going a lot longer than I thought, but how does a case get to the Supreme Court? Well, we know on a handful of cases over treaties and federal ambassadors and federal office contestants and things like that, that can be directly brought to the Supreme Court. Very, very rare. Most cases are brought through appellate review. No case that I know of, almost now, it's all discretionary, meaning the Supreme Court doesn't have to hear a case. And I've had people tell me, well, you always have a right to appeal your case. You always have a right to ask the Supreme Court to hear a case, and you do have a right to have appellate review, but that doesn't mean necessarily the Supreme Court. So say I went through a case, I'm representing a client on some kind of drug distribution case here in Massachusetts, and it's a federal case, for example. And my client's convicted, and I think there's an error of law. I'll get to that in a second. And do I have a right to appeal? Yeah, but not necessarily to the Supreme Court. First, I have to exhaust my appellate review in the lower court. So I'd go to the First Circuit Court of Appeal. And let's say this First Circuit Court of Appeal ruled against me, and I think they're wrong too. I can appeal it to the Supreme Court, but the Supreme Court has almost carte blanche discretion on whether or not to hear the case. Over 10,000 cases, this is back almost 7 years ago, the quotes from your book, over 10,000 cases in a 1-year period were appealed to the Supreme Court, and they made decisions on 77 of them. It's less than 1%. So, and what can you appeal to the court? You could only appeal questions of federal law. So if it's a state court case, unless a federal issue is raised, you're out of luck. You can't even bring it there. So if you do have jurisdiction, meaning a federal question, and you're aggrieved or you think you've made there's been an error made in the law, we'll get to that in a minute, in the lower court, you can try to appeal to the Supreme Court, and that's called a petition for certiorari. It's a Latin term. Please hear the matter. Supreme Court has discretion, and usually they want to hear decisions where there is a distinction happening in the First Circuit up here in the Northeast to the Ninth Circuit out in the West Coast. They've had a very similar legal question with similar facts decided differently between those two appellate courts. Now we have a dichotomy in the federal law's interpretation. The Supreme Court will generally be more likely to hear that kind of case than other federal question cases. So you need 4 of the 9 members to just decide to want to hear it. Doesn't mean they're going to rule in your favor or think you have a great appeal. They just think there's a question that needs to be resolved on the federal level. 4 of them have to agree, and that's called a writ of certiorari. Petitions asking, writ is granting. So the writ of certiorari, it's called the rule of 4. 4 members of the 9 decide to hear that case before the Supreme Court. Now, when you hear this term appellate jurisdiction, you're not appealing facts. This is true on the state court level as well as a federal. It's a great civic learning moment for this little lecture thing I'm putting up. So if I have a trial and I lose and my client says, I can't believe those jurors thought I stabbed my wife, I want to appeal. I can say, well, we have a right to appeal, but we have to appeal based upon an error of law. Errors of fact are seldom litigated on the appellate level. It's just not part of their jurisdiction. That's why if you ever go to the appellate court here in Massachusetts, I've gone several times, or go to the Circuit Court of Appeals, or go to the United States Supreme Court, guess what you won't see? You won't see a place where witnesses will give testimony. You won't see a place where jurors will sit, because what they're going to do is review what happened at the trial court, read the transcript, hear attorneys argue cases and statutes and legal principles that either argue that the case was done appropriately or there was an error of law. An error of fact would be that the jurors believed my client stabbed his wife. An error of law would be that they allowed a psychic card reader to come in and say, based upon her psychic window, she could tell the defendant had ill feelings towards his wife. That's an error of legal precedent. That's an illegal error of evidence. That's an error of law. So that's why out of every 1,000 cases that get tried to conclusion, only 1 or 2 get appealed, because most judges make sure that the trial court is what? Conducted fairly without errors of law. So when we go to the appellate level, when you go to the Supreme Court, you're arguing legal theory that the law has been misinterpreted, or if you're on the other side of the coin, that the law has been applied appropriately. Appellate jurisdiction is very, very narrow. And in the past, maybe we'll do it again in the future, we used to take a thing to the Supreme Court of Massachusetts, just Massachusetts law, for the most part. And the students would go there, and there's like different seating arrangements, a beautiful court, John Adams Courthouse in Boston. And the students would come in, and no matter how many times I went over in class, they'd come in and they'd say, oh, is that where the jurors are going to sit over there? And I said, there's not going to be any jurors over there. He goes, oh, is that for the witnesses where they're going to hang out? Goes, there won't be any witnesses here. And they say, why not? I said, I went over this 1,000 times, I guess, but sometimes you have to see it in action and start having it kind of melt in. I said, they're going to have 2, maybe multiple attorneys. They're going to go up to that microphone and they're going to argue to the panel of judges that something at the trial that occurred was an error of law, the way the law was applied, interpreted, or procedure was conducted in an erroneous or error-filled way. That's it. Very narrow. So every so often I'll get a client come to my office and goes, I want to take this case to the Supreme Court. I said, oh, so you don't mind me losing at the trial court? Because remember, if I'm going to the Supreme Court, I must, as a defense attorney, I'm going to be arguing that there's an error of law. So I had to have lost at the trial court level, right? And the second one is there'd have to be a federal question. Otherwise, state law questions go through the state appellate system. I think it takes a while for those kinds of things to dawn on you. John Marshall, in my opinion, the most significant Supreme Court decision, the most important Supreme Court case ever decided. Marbury versus Madison, creating the concept of judicial review, giving the Supreme Court the power to nullify, at the time, federal legislation as unconstitutional. We know later cases will say the president goes beyond their power, can be curbed, and then later state law. But all of them ultimately come under the concept of judicial review. And there is a thing in here, and I've read it many times too, that John Marshall, upon his death, 1830 something, I think he died, 1835, after he died, they did the Philadelphia, the Liberty Bell, and supposedly the Liberty Bell cracked when they were ringing it to acknowledge the death of John Marshall, because he was such an iconic figure in such a long period of time in the development of United States legal theory and sort of the checks and balances in government. I know some of you have to do a paper, and one of the things I think is always a great topic, especially in Constitution, you can do a biography on some of the famous justices. That's what I have a master's degree in law, and I had some professors that I developed their philosophy, like, let students write about what they want to write. So I always did things on John Marshall or Judicial Review all the time. That was my favorite topic. So going through this, there is a couple of things I did want to mention in here, that in the third article, it mentions the fact that in all criminal trials, there will be a right to a jury trial. So a lot of people think the Bill of Rights protects us to have a right to a jury trial. It does, but the framers were so concerned that before they left Philadelphia, remember, they didn't come up with the 10 Amendments, the Bill of Rights, until 2 years after the Constitution was adopted. They wouldn't leave that building without the inception or the capturing of the right to a criminal trial in the federal system. And it's right here in Article 3. If you read in Article 3, the trial of all crimes shall be by jury. And it also gives the jurisdiction. It has to be in the state where the crime was committed. The sanctity of jury trial rights important. A lot of people don't like jurors in some ways because jurors are made up of such a mixed bag of individuals. In Massachusetts, the federal system's not too much different. 18 to 70. Usually they don't want you to have certain federal convictions of certain federal crimes to sit on a jury, but other than that, you can be anybody. A lot of people like, cops can't be on jurors, lawyers can't be on jurors, judges can't be on it. That's not true. My last jury trial, the clerk magistrate in Worcester District Court, or Superior Court, was in a jury pool, and he actually got into the box, the actual jurors, and he raised his hand. He came and goes, "Hey, I know Jim Corman, and I know the prosecutor." And the judge says, "Well, do you think he can be fair and impartial?" He goes, "Yeah, of course." And then the judge asked me, he goes, "What do you think? You think it's okay to keep the clerk magistrate on?" And I knew him, and I thought he was very fair. I said, "Yeah, I'll keep him on." And the prosecutor said, "Yeah, he's good to me too." And we have this process, but we know very little about the jurors. Unlike television, when you pick a jury, these are basically members of the community. You know very little bit about them except for where they live, what their occupation is, their marital status, their education level, and of course, my favorite, their list of biases. And what do most of us think we have? We have no biases. Or you try to be a wise person and you put on, "I've got every bias in the world, so I can go golfing this afternoon and not have to sit in this juror." Be careful when you try to do that. Judges will often not release you completely. They'll put you down downstairs and you'll sit there all day anyways, for multiple days. So the right of preservation at trial for a jury is preserved in Article 3 of the United States Constitution, as well as in portions of Amendment number 5 and Amendment number 6, and Amendment number 7 for civil trials. But I'm way off track. And that's Article 3 in a nutshell. I know I rambled on quite a bit, on and on and on and on, but it's important because I don't want you to call it a test. I won't knock points off you if you say 3 co-equal branches of government, but this is it. We talked about Article 1, the checks and balances inherent in the bicameral legislation itself, in the process by which a bill has to become, through a process to become a law, and how difficult that is. Checks and balances, limiting their authority, only granting them enumerated powers, only giving them so much power and reserving the rest of the states, and then the president having the check on them by being able to veto actions of the legislature, and the legislature having a check on the president by having the Senate give them consent of judiciary picks, but also cabinet positions have to be approved by the Senate, but also the the legislature having the power to overcome the president. Then comes Article 3, and initially wasn't coming to life until Marbury versus Madison, where the court says we can strike down acts of the legislature. And initially that was one case, but later cases will expand that to acts of the president, the executive, and also acts of state legislatures and state governments. Really, really big chapter. I went really, really long, do other activities, listen to me in the background. Hopefully you'll pick up some nuggets. The book is excellent. I might throw up a video about Article 3 a little bit. I'll probably put up an article and maybe a video just about Marbury versus Madison. You have to know that case, most important case in the history of the United States Supreme Court and about the Constitution. And it is History of the Constitution class. Be well.